I'm going to call to order the August 17th, 2026 Planning and Zoning Commission regular meeting to order. Before we do anything, we're full tonight. In capacity, we got people waiting outside. Under advice of council, we're going to move the meeting for file 2026-5, the text amendment for the Town Center Village District. We're going to hold a special meeting for that because we want to hear everybody. Everybody's got something they want to put on the record. We're going to move that to a place where we can better accommodate the larger number and to the best we can the Zoom options. We're going to move it to September 1st. It's a Tuesday night, 7 o'clock. Location will be determined as soon as we find a place in the next couple of days. We're going to publish the location. But the meeting for the file 2026-5 special public hearing for the text amendment is going to be moved to a special meeting September 1st. It's a Tuesday night, 7 o'clock. So if you're here for that, we'll see you in 2 weeks.
Question. There you go. Can I have a quick question?
Well, let's make a motion. So with that, I'll enter. So the applicant is represented here by Ms. Hahn, and she has given her consent. Do you want to make it? Yes. Okay.
At this point, the time period that you have to review this has come to an end. We'll end today, so you need the applicant's permission to extend. The applicant, Selective Development LLC, is willing to extend it, and the time is related to the next meeting, so it's September 1st, and that's what we need from us.
Thank you. Thank you.
Anything else, sir?
Thank you, Ms. Hahn. With that, I'll entertain a motion to table public hearing for file 2026-5 for a special meeting to be held September 1st, 2026, 7 o'clock, at a location to be determined. Brian, is there a second? Thank you, Jen. Any further discussion? All in favor? Aye. All opposed? Motion carries.
Everybody, make sure you show up at the meeting. Everybody, get your friends.
Show up.
Show
We
up.
got
This
2
is
more
serious.
weeks to rally the forces here. 2 more weeks to bring everybody you know.
Oh, absolutely. You got right award. Make sure the seniors get you. Spread the word as much. I know, I'm serious. Older people, younger people.
In order. Thank you. Item number 1, roll call. Jake Burns, Chairman, is present. Vice Chair Christine Sinopoli. Secretary Jeff Gerard. I'm sorry, Secretary Brian Dunn. Present. Jeff Gerard.
Present.
Zoom. Jen Metcalf.
Present.
Kevin Key. Present. Jeff Kaplan is not here. Art Christian. Present. Ryan Busolari.
Present.
Thank you. Moving on. Item number 2, public comment. Opportunity for anybody in the public to make comment on the record for anything that's not on tonight's agenda. So if you're here to make a comment on something that's not on tonight's agenda, now's your opportunity. Seeing nobody on Zoom, nobody in the meeting. Moving on to item number 3, which we are postponed. Item number 4, old business. We're moving on from that. Item number 5, new, yes. Excuse me?
She had a question. So I'm deaf,
Okay.
and I'm using a captioning device. Did
Okay.
I miss the option for a public comment?
Okay, so if it's a public comment for something that's not on tonight's agenda, so if it's on tonight's,
Hello?
it applies.
Yeah, so if it's about the text amendment, then I would suggest you come to the meeting in 2 weeks.
It's the irony of having to move it from the center of town, from this
Yes.
location. Why didn't we just change the sign outside that allowed the number of people in the meeting?
Yeah.
Because if we just changed that, we could put 250 units of people in there, right?
Thank you very much. Thank you. Moving on. File 2026-7 Affordable Housing Site Plan Application pursuant to Connecticut General Statutes 8-30G for the construction of a 100-unit multifamily residential development on an addressed parcel located on the east side of South Main Street to the rear of 156 South Main Street, known as Assessor's Map 44H, Block 47, Lot 216A, applicant MI22 LLC. Accept and set the public hearing for Tuesday's, for September's meeting.
September's meeting, and just to remind the commission, this is, although it's setting a hearing, it's a site plan, you have 65 days to make a decision. Remind
65 days from the September meeting. Today. Okay.
make a decision.
Okay. Okay.
When is the September meeting?
21st. The September meeting is September 21st.
Thank you.
What was that?
Yeah, can you guys speak up? It's hard to hear you.
We're setting the date for a public hearing for file 2026-7 Affordable Housing Site Plan Application pursuant to Connecticut Statutes 830G for the construction of a 100-unit multifamily residential development on an unaddressed parcel located on the east side of South Main Street to the rear of 156 South Main. Map 44H, Block 47, Lot 216A, applicant MI22 LLC.
Is this St. Joe's?
It is. We're just setting the public hearing for that tonight.
Didn't you already have public? I've been to
This is a
couple.
new application, ma'am. It's a new application.
Interesting.
I'll entertain a motion to set that public hearing. Thank you, Brian. Is there a second?
Second.
Thank you, Jen. All in favor, say aye. All opposed? Motion carried. The public hearing will be in the September meeting. There's nothing else on tonight's agenda in terms of public hearing. The rest of the night is simply going to be a training session between council and the commission, so there's nothing else tonight on the agenda for the public hearing. Item number 6, Commissioner training session with Attorney Carl Landolina. Carl, I appreciate you coming out tonight.
Sure, of course.
I know you came out a few years ago, I think it was 2022, and gave us a really useful and helpful time to kind of give us the rundown of everything that's going on. The commission looks much different now than
It does.
it did in 2022, so I thought it might be a good idea, talking with Bill, to call you back out again to kind of.
Sure, I'm glad to be here. Just the one thing we can always count on is that commission members change over time. So, again, I'm Carl Landolina. I think I've met most of you here before. I haven't seen Art in a long time. Anyway, I don't really have anything prepared, but I'd rather kind of jump into, kind of reiterate things that you probably already know and understand, but it's useful just to kind of hear them again. And then I'm here to stay as long as you want. I'll answer as many questions as you have, and we'll see how it goes.
Yeah.
So, as a zoning commission, you understand what your role is in shaping the look, the feel of any community. And you are guided by a few important documents. One is a very broad document, and that's your plan of conservation and development, which you're required every 10 years to go through and at least, you have a question already, Christine?
Well, Carl, do you think you could just back up a little bit? Because could you start with like the primary documents that govern and then maybe lead into the POCD?
Yep. Well, the PLCD is one of the primary documents.
Well,
Are you talking about statutory
state
documents?
statutes, like, yeah, what the succession of what governs. Because
Well-
no one ever told me to read, 8-2. I kind of figured it out over time,
Mm-hmm.
like, I was even rereading it this past weekend. Or
All right,
maybe
if you
this
want to
past
go
week.
back to, I guess we'll go to the beginning and the
Well, it
state
would
of
help me
Euclid,
chronologically.
Ohio was one of the first towns to have zoning regulations. And there was a claim by folks in and around Euclid, Ohio, who claimed that regulating the use of private property violated the US and probably Ohio Constitution because it was a taking of my property, and under one of the amendments to the Constitution, you can't take someone's private property without justly compensating them. And there were folks who decided that regulating my property as to specific uses that would be allowed there was the same as taking my property in some fashion. You're telling me what I can and can't do. And they brought the city of Euclid to court, and that ended up in the United States Supreme Court in the sort of seminal case for zoning law. And the US Supreme Court said that there was each town has a police power, a number of police powers, and I don't just mean the police department. Any police power is the power to regulate any kind of activity or uses in your community. And the Supreme Court said the folks who would be best able to make those decisions are local folks. And when we talk about police powers and the exercise of police powers locally, what we're trying to accomplish is a sort of balancing act between the needs of the individual versus the needs of the community. And I haven't read Euclid since my first or second year of law school, so I'm going from distant memory. But essentially the court decided that with reasonable restrictions, and of course lawyers like to argue all the time about what's reasonable and what's not, but with reasonable restrictions, that under certain circumstances, the use of that power to regulate the uses of land was a permitted thing that communities could do as long as it didn't go too far. And because in this particular case, the needs of the individual to use his property for any use should be secondary in some fashion to the use or the needs of the community to have certain expectations about how things are going to look, feel, that kind of thing in any given community. So that's sort of the genesis of the zoning in the state, in the country of the United States.
So Carl, Christine Snopley, so I live in a residential, so I can sort of have that expectation that an Amazon warehouse won't be built in my backyard,
Well,
right?
now you're jumping ahead 50 years, so.
Oh, okay,
Yeah,
okay.
so okay. So Euclid comes out, and a lot of states start drafting what we would call enabling legislation. All right, so municipalities, generally speaking, have no authority to act on their own until the sovereign, which is the king, and in each state, that would be the state government, gives you the ability to use some of these powers that they're going to bestow on you. And so state after state started bestowing upon their communities these enabling statutes for many things. I mean, the zoning statutes are not the first enabling statutes, right? Now, years ago, in Connecticut, the enabling statutes go back to the 20s, I believe, in some form. They're not as sophisticated as they are now. But prior to that, if you wanted to have your community take certain actions, that you could go to the General Assembly at the State House and ask them to adopt a special act for you. A law that only applied to you generally. So, for example, before, and actually there are many towns whose zoning commissions can date back to special acts. There are many of the fire districts around and other taxing districts, for instance, lake associations that are special taxing districts. School districts used to be, you know, you have old schoolhouses here in town, right? They go back to the 1600s, I'm guessing, right? And oftentimes they would go to the legislature and say, we want to start our own school district out here in whatever West Suffield was called 300 years ago. And the legislature would say, okay, we're going to give you the power to do that. And we're going to dictate to you how you, under what circumstances you can do it and that kind of thing. So there are towns that, and there still are towns that aren't necessarily governed under the state statutes when it comes to zoning. Some of them are still using special act powers given to them by the legislature 60, 70, 80, 90, 100 years ago. Those would be mostly big cities. But so,
Like Hartford has special act powers then?
not zoning. The one I can think of would be New Haven, which the zoning commission in New Haven is actually its board of aldermen. They were given that power a century ago, probably, if not more, and to this day they still retain it.
This doesn't have anything to do with like the Dillon principle
I don't know what the Dillon principle
or
is.
home rule, or that doesn't?
No, that's
Okay.
that's sort of different. Those are
Okay.
that's charter questions and not zoning questions. But
Okay.
it's sort of like that. There are a lot of towns that were given charters by the state, but most of the towns in Connecticut have adopted their own charters. You have your own charter. That's your organic law of how things are supposed to run in general. So the state of Connecticut adopted these enabling statutes and said, you have the authority to regulate uses of land, individual uses of land in your town, as long as you adhere by certain principles that they laid down. So for years we've called that Euclidean zoning, which the Euclidean zoning is what you have here for the most part. You may have some newer style zoning. We call that form-based. I haven't heard that word used around here, but a lot of towns are very happy about are proud of their form-based zoning. But in any event, so the state gave you power to do that, and you created zoning commissions, and then those zoning commissions created zoning regulations. All right, Euclidean means that you've divided up the town into certain districts. We'll call it a grid. It's not really a grid. Those lines don't, you decided where those lines go, and you actually move those lines occasionally, and you said, okay, this is going to be a residential zone. And these are the uses we're going to allow in residential zones. And there's a list of them. You have that today. We're going to call this area of town, we're going to draw lines in another area of town, we're going to call that business zones, commercial zones. And then we're gonna draw lines around other parts of town, and we're gonna call those industrial zones. So those sort of the core zones any town would have, residential, business, commercial, all right? So that's sort of the Euclidean model, which has been around since that case. And now it's become much more complicated. You have mixed zones, and then you have all kinds of things. So, but that's sort of the genesis of why you people are sitting here today and the genesis of your regulations. So jumping forward to the plan of conservation and development, that's sort of like your overall, it's like, how old is your current plan?
2022.
All right, so you're not quite halfway through your 10 years. And again, you're supposed to do that every 10 years. Sometimes it doesn't get done. The state does have some power to make you do it. They don't really exercise it a lot, but for many years, towns were sort of dilatory in getting that plan done every 10 years because it can take up a lot of effort, time, and some towns hire consultants, and that could cost you a lot of money. But in any event, so in that plan, you set these overarching goals and on how the bigger picture you want that to look like. And then you go through and you say, okay, these are the goals for the next 10 years, and here's how we intend to implement them. And oftentimes, one of the ways of implementing these goals is to review your zoning regulations and say, how can we revise the zoning regulations to implement this goal? So, and then you spend the next 3 or 4 years either following through with the plan and changing your zoning regulations to implement the goal, or you don't. Let's say one of your goals, there's always a section on housing, right? And one of your goals is to make, I hesitate to use the word affordable anymore. So I didn't necessarily, I don't believe I'm the first one to say this, but I call it accessible, to differentiate between what's affordable under statutes and what's reachable by people of, let's say, average means or what have you.
Carl, a lot of people are saying affordable with a capital A to mean affordable housing. I've heard that used repeatedly.
And a small a for the others?
Yeah,
Okay.
they just say affordable with,
Yeah.
I'm just sharing now.
Okay. I like my word better.
Okay.
Accessible.
Is there a difference between like the legal definition of affordable with a big A?
Well, affordable, the big A does have a definition,
Yeah.
which I'm sure you've read.
But
And-
accessible means it's actually affordable, or it's affordable with.
I use it, this
me.
is all, again, this is a colloquialism, but I use it to mean, you know,
Not
it's
exactly
not
affordable.
830G,
Yeah.
but it's housing that is more accessible to people of average means, so to speak, whatever that means. All right, because nobody has to, you don't have to go anywhere. And, actually, the New York, the Journal, Wall Street Journal had an article about affordability in various areas of the country. And a few months ago, they cited Hartford County as the least affordable, or least accessible, least reachable. The prices were growing faster than anywhere else in the country. That was 4 or 5 months ago. So, and we were one of those communities here, and, but I guess I digress. So from there, you start with your regulations, right? And of course, 8-2 is the statute that enables you to pass those regulations. And 8-2 probably started out as a couple sentences, and now it goes on, right, where you can't really read it in one sitting without trying to digest it, without saying, oh, I'll come back and finish it tomorrow. So it sets forth certain criteria and certain limitations on your powers, is imposed on you by the state of Connecticut, right? And that leads you to the documents that you have now. I will tell you that there are certain uses that the state of Connecticut has decided are too important to be left in the hands of local authorities, and decided that they're best reviewed and approved by state officials. Utilities being the biggest one of those things. Obviously, if someone wants to build a power plant of a certain size, they don't totally bypass you, but it goes to PURA, the Public Utilities Regulatory Agency in Hartford, which used to be called something else, the Siting Council. So, because who would ever agree to have a 30 megawatt power plant in their backyard? Nobody.
How the solar farm could approve that.
You know, so, but for the most part, your commission has reasonable, can exercise reasonable power over the use of individual properties. So.
Carl.
Yep.
In terms of the function of a meeting, again, we have some new members here, some people with past experience on other commissions from other towns. Could you just run through us the basics of the meeting, when it's appropriate to speak, who can speak, so on and so forth, that kind of stuff?
Sure. So, well, let me go back and I'll kind of add in when I talk about the different types of permits.
Okay.
There's different levels of permits in your zoning regulations.
Can I ask a question about the POCD though? I mean, we have the POCD, but I was reading 8-2, and it talks about a comprehensive plan and in consideration of the POCD. And
They're different things.
Right, that's what it leads you to, grammar-wise.
Mhm.
Where is that comprehensive plan?
The
or
courts
is that?
have said that the comprehensive plan is your regulations and your map.
Thank
Those
you.
two items are the comprehensive plan. Nothing beyond that.
Thank you.
So that's when they talk about comprehensive plan, all right, when judges had to decide what that meant, and they read the stuff that the legislature wrote, which in many cases is not as decipherable as it could be. You could have just said your zoning map and your zoning regulations, but nope, someone said, no, we're gonna, some consultant said to the legislature, call it the comprehensive plan, and there you go. So the courts have decided that's what it is, just those two things. So there are, I guess essentially we'll call them 4 different levels of permits. The lowest level would be a zoning permit. And that's usually a very administrative process that is coupled with an application for a building permit. Someone walks in, wants to get a building permit for a house or some other building on a piece of land. That routes its way around town hall, right? The fire marshal might look at it, the building inspector would look at it certainly, wetlands agent might look at it, all kinds of folks would look at it. And then the zoning enforcement officer or Bill, somebody in the planning department would say, is this a use that's as of right in this particular zone without the necessity for any other type of permit from the Planning and Zoning Commission, the other 3 types of permits that we'll be talking about. And if it is, then the zoning enforcement officer or Bill or someone at the zoning department will sign off, just like the fire marshal will initial, and then the building inspector will issue a permit, as long as everyone sign off. That's a zoning permit. All right. Sometimes it's not connected with a building permit. Sometimes people are doing things in on their property that don't require building permits. But some of them may or may not require a zoning permit. So one of the ways that the zoning department learns of things going on is through the building permit process. So when there's no building permit allowed, it's very difficult. I mean, you know, you don't have a satellite in the sky watching the, I don't know, how many acres or square miles in Suffield?
Not yet, we don't.
27, okay, so there's not one satellite dedicated to watching that 27 square miles to see someone put a shed in their backyard that was smaller than the threshold for getting a building permit. And now, and maybe they needed a zoning permit, maybe they didn't, or maybe they stuck it in their rear yard or the side yard or on their neighbor's property or whatever else might occur out there. So some of your role, you know, unless you're spying on people, it's difficult to know when that occurs. But that's the lowest form of permit. Most people who require one usually get one, but stuff falls through the cracks, at least at that level. So the next level would be what I would call an administrative type permit, but an administrative permit that goes through you guys. And the two major ones would be a site plan approval and a subdivision approval. And they're administrative in the sense that there are very specific requirements laid out in your zoning regulations as to compliance and the ability to seek, demand an approval from this board for one of those two uses. So that you have in your site plan regulations, you have very specific items that must be checked off, all right? You must give me certain documents, they're listed, A2 survey, whatever else it might be that's requested or listed there. There might be a catch-all that says, and any other documents the commission may deem necessary to judge this application on its merits. Those two applications must be approved if I check all the boxes. There's no discretion. That's why we call them administrative approvals. So if I've got 27 boxes to check off in your site plan application checklist, and I check them all off, coming up with a reason to say no to that application would be extremely difficult, or coming up with a reason that would be supported by law is almost impossible. If I met those standards, right, I've got my map, my north arrow's pointing in the right direction, I comply with all the zoning regulations as to bulk and area requirements. You all understand what those are, right? Those are in your tables. It says, okay, this is the uses that are allowed. You have to have 20,000 square feet to have a lot in this zone and 30 in the next and whatever. Your setbacks, all of that kind of stuff, coverage is in there. If you meet the bulk table requirements and all the other requirements, then this commission is legally required to give site plan and subdivision approvals. Now, a lot of towns do not have public hearings for site plan applications. They don't have them. The statute in the law says you can if you want, and your regulations do provide for that. All right, so you will, if you decide to, have a public hearing on a site plan application. The courts, though, in the law says that just because you have a public hearing on a site plan doesn't turn it into something else. It's still a site plan application. And you can't look at things outside of the requirements, the specific condition standards in your regulations, and ask questions into things over which you shouldn't be concerned. All right? For instance, we're going to talk about this in a second, but so in special permit applications, you have the site plan requirements, and then you have other sort of broad regulations where you can talk about things like, well, harmony is not a good word to use anymore, but how does this really fit? I know it's got all, crosses all the Ts and dots all the Is, but is this a good thing for this area? And you have these sort of vague, broad, longer regulatory sections that allow you to pry or question or delve into those kinds of issues. And then you have also general conditions of health, safety, welfare, and property rights.
Carl, I'm not getting what you're talking about, because you said example of special permits, site plan requirements, okay, I get that, we've gone over stuff. And then you just said others. And what are you talking about, like?
Trying to differentiate between site plan applications and special use permit applications, because you can't take a site plan application and turn it into a special use application just because you want to, or you'd like to find out whether this is in harmony or are the other sort of broad regulatory sections of your zoning regulations, or just because you're having a public hearing. All right? You can't do that. Just because you're having a public hearing doesn't mean your site plan application is now something more than that, like a special use permit application.
So are you saying that in the Suffield zoning regulations, there's a whole bunch of stuff listed under site plan?
Yeah,
And it's check, check, check those boxes?
correct,
And then there's a whole bunch of stuff listed under special permit?
correct.
And is there any overlap?
Yes, the site plan, every special permit must have a complying site plan. All right, in some towns I've seen this, I don't like it, but they'll make you file a site plan application and a special permit application. And the courts have argued over whether they're really different things or is it combined into one cohesive unit.
And you're saying that there's nothing out there that supersedes
Supersedes what?
the two lists of checklists, the two
All right,
check-
let's talk about site plan, let's go back to there. I have a list of 27 items in my regulations, I don't know how many, I'm using 27 as a made-up number, that says when you have a site plan application, you must show me that you comply with these very specific, detailed, non-discretionary conditions in my regulations, these standards. All right? If I show you that, whether you have a public hearing or not, you shouldn't be delving into anything outside of those standards. So to ask somebody, can I see your regulations? Well, I'm gonna go here. So here's a standard in your special use permit application, which does not apply to site plan applications. The location and size of the proposed use. In other words, this is saying you must make these findings when you approve a special permit. All right? That the location and size of the proposed use, the nature and intensity of the operation associated with the proposed use, the size, shape, and character of the site in relation to the proposed use, the relationship of the proposed use and site to adjacent land uses, sites and streets giving access to it, are such that it would be in harmony with the appropriate and orderly development of the district in which it is located. That's a very broad thing, right? I can almost fit anything I want under that. But that's intentional. You want to be able to do that. But if you start asking questions to find out whether you think the site plan application complies with that standard, you're way off base. You shouldn't be asking those kinds of questions because they don't apply to special permits, whether you have a public hearing or not.
But that regulation is under special permits?
Correct.
Okay.
But I sit here, not here, in front of commissions all the time, and I hear them and watch them blur the line between site plan applications and special use applications because they want to know whether standards like these broad general standards, are being complied with in a site plan application. And a lot of times, you have to understand, when an applicant comes before you, he comes before you with his hat in his hand. He wants something from you. All right? And
Well, and that's, a lot of the information that we get from the public
Is,
would be related to that, because that's more of a feeling than a standard.
exactly, right, that's, yes, yeah, you're 100% right about that. That's why some commissions do not have you have to have it in your regulations if you want to have public hearings on site plans. They have to have it in there. Some communities have talked about it, they said no, because we don't want to deal with that. Because look, this is nuanced stuff for zoning attorneys, nuanced stuff for people who sit here week after week or month after month. It can get lost on people who don't study this. But most times, when people come in here and you have a public hearing, that's what they're doing, all right? And you let them do it, because you're not going to say, well, unless it gets way off track, the chairman might say, well, you're getting a little off topic here. We're here to talk about whether this complies with the 27 requirements in our regulations.
Can I get the citation of that harmony language, because that's under special permits?
Yeah, it's in your regulation.
What is it? Because I'm gonna go back home when I'm doing my homework and,
It's section 14. I don't know, I'd have to start to get the B's and the ones and
Oh,
the
Bill, can-
Roman numerals.
Can you tell us, Bill, there?
Section 14B, I think. 1B1.
Is there a subtitle there?
Standards for approval.
It's on page 5 of section 14.
Okay.
So for zoning permit
Thank
and
you, I
an
appreciate that.
administrative permit, pretty much most of the work is done for us, or a lot of the work is
Yes,
pretty much done for us.
because you're not, right,
Right.
and how many times are you gonna sit
Right.
there with a ruler and measure?
Right,
Staff does that work for you,
Right.
and gives you a report.
right.
But
And we can ask for conditions on approvals, but for the most part, it's no.
so, we're gonna get to that in a second. So the other one is the subdivision, which again, if I meet the regulations, you have to give me an approval. Now, the thing with site plan and subdivision applications, all right? Some towns will require, the subdivision public hearing is a little bit of a different animal. Some towns will divide up the process whereby a subdivision application will go through the approval process into the number of lots. If you have 5 or fewer lots, we're not going to have a public hearing. They might call that a minor subdivision plan. And if you have 6 or more, we're going to require a public hearing. The statute only says that you must have a public hearing on a re-subdivision. You must do that. And a re-subdivision is when you take a piece of land that's already been part of an approval for a subdivision. All right, so I've got a 5-lot subdivision plan, and my lots are 20 acres each. Right? I get that approved. One of my owners, 20 years from now, who owns that 5 lots, says, well, I want to carve my 20 acres into 5 separate lots. That's a re-subdivision. Okay? And the subdivision itself is the division of any property into 3 or more lots intended for development or building purposes, whether now or in the future. So sometimes people come in and they think, so we call the lack of dividing your property, or the dividing your property without subdivision approval, we call that the free split, the free cut, right? So someone comes in and says to Bill, I got this 10 acres, I want to split it into 2 5-acre lots. I shouldn't have to do anything, right? It's my free split. Everyone knows that. There are 2 words that most people know, free split and grandfather. Okay? People understand that, especially the free split one. And then you have to, now as time goes by, there's fewer and fewer free splits, right? Because it's typical, acres that is in the same shape and configuration of a farm out here that's been there since subdivision regulations. That's how we determine it. We go back to the date subdivision regulations, not zoning regulations, subdivision regulations first came into Suffield, which Bill could probably tell me that, but I don't have no clue. 60-something?
73.
73.
Wow.
So if I took my land and split it into any number of lots before 1972? Three. See? The next time I split one of those is a free split. But if I did it after that and I had to go get a subdivision approval, the next division is not. Or if I take two lots, I use my free split, no matter when I was able to do it, because it's been in that same configuration since before 1973. I got it right that time. And I want to divide one of those lots into two lots. Now I've created a third lot. And I may not get my free split. So sometimes, typically I've been asked this, many times. I come in, if there's a question now, somebody has to go back and do the title and look at the land records and the zoning records and say, if I look at the description, everyone who owns property has a deed and there's a description, right? And so you look back and say, what's the same description as the guy I bought it from and the guy he bought it from? And I get prior to 1973, it's always been in the same configuration, then I know I've got a free split or I don't. All right? So I'm throwing a lot of stuff in. But so the other thing with these type of administrative permits, the site plan and the subdivision, if you don't approve them with a certain amount of time, and that starts out at 65 days, they're automatically approved, whether you want to approve them or not. And there are a lot of cases about, when did the date start? When, because sometimes, people argue over, has it been 65 days? Now, there's other statutes that say, well, we can extend that on even those administrative type permits for another 65 days. So, but that has to be with the consent, as you know, of the property, which most property owners will give you, because not consenting could lead to an adverse decision. When a judge calls you and says, I need 10 more days to write my decision in your case, did you approve? You say, of course you don't. Use as much time as you like. Even though my client's been waiting for 5 years to get to this point. So you almost never say no to a commissioner or a judge. So those are the administrative type permits, all right? And sometimes the lines get blurred and it's hard to stay in the lane you're required to. But again, the most important thing is, I think, when you have public hearings, doesn't mean it's something else, all right? So, and there was a recent case, Bill knows the name of it, I've forgotten it, I'm getting too old, about 2 or 3 years ago, where, and it was interesting that the Chief Justice of the Connecticut Supreme Court actually wrote the decision, and they don't usually write a whole lot of decisions. But the Chief Justice at the time decided he was going to write a decision. And this was a zoning case where people were trying to build a crematory in a no, it wasn't residential, it was an industrial zone, actually, I believe. And people obviously, for some reason, that's a use that people don't really like around. It's like the same reason people don't do their. Well, we tried one of the first crematory cases out of Enfield, and that was a constant noise, the smell. But crematories have an air permit that's given to them by the state of Connecticut. So, but I digress. So, and there was a public hearing, and I believe it might have been one of these administrative type permits, and it might have been a special permit. And either way, what the Chief Justice said is most of what you hear, unfortunately, at a public hearing is not really relevant. Okay, because people are going on feel and,
Emotion.
Yeah, emotions, that in order to turn something down, no matter what kind of application it is, you must have relevant, substantial evidence to back up what you're saying. I just don't like X near me, that's that's not substantial relevant evidence, as the court would find. So, you have public hearings, people are gonna say, and they're entitled to say what they wanna say. And you'll be surprised, many people give you substantial relevant information. But occasionally you'll get information that's, you know, that's not so substantial or so relevant. So the next,
If somebody in the public hearing gives you, for an administrative permit, site plan,
Mhm.
you still can't really do anything with it, can you?
Unless they're, you know, sometimes you'll get engineers who'll come in and say, you didn't comply with standard 25. It requires 2.5 inches, he's got
Yeah.
2 and
Okay.
whatever. So that would be relevant at a public hearing for a site plan.
So expert professional kind of.
Yeah,
sort of
something
thing.
that
Okay.
somebody is locked into, because the purpose of the site plan regulations or standards is to be very precise.
Right.
Not to have any wiggle room, all right? You know?
Does it matter where the professional, like, if it's out-of-town professional, somebody comes in from Summers, it doesn't
Now,
matter?
if you want to talk about that, make a note to talk about expert testimony,
Okay.
all right? We can talk about that.
He is
So, then we have the next discretionary type permits, which we'll call, you know, things like special permits, right? That's a discretionary permit. It's discretionary in the sense that you have these standards which are intended to be broad to allow you to make inquiry in all kinds of things. Rather than, does this fit the regulations, you can then get to the next step, which is this fit the area? Does this fit the community? Does this fit the neighborhood? Is this good for the neighborhood? Is this good for them? All right? Now, generally speaking, if it's permitted in the zone, especially with site plans and subdivisions, the commission has already decided it fits in the neighborhood, right? If I zone your property residential and you ask me to build a house, well, I've already decided that it's a good use there, right? The line gets a little blurred in special permits, but those are specific locational things. It's permitted in the zone, but maybe not here in the zone. Or it might not be a good fit, this particular location, but elsewhere in the zone it might be a good use. Those are the kinds of things you can get into on these discretionary type permits. And then you have public hearings and it draws out the time limit, right? You have 65 days to open a public hearing, 30 days, 30 days, 35 days to close it, and then 65 days to make a decision. So that's, if my math is correct, 130, 160,
yeah.
165 days. And then I can ask for, or you can give applicants another 65 days for further continuances. So that's now around 230 days for this process to unfold for a permit that requires a special permit, like a special, or a public hearing, a special permit.
Split those up,
I'm
those
sorry?
extra days, right? You can split those extra days up.
Yeah, you can sprinkle some of them in anywhere you want, like, but once you get a total of 65 additional days, you're done. So sometimes the commission asks for that time up front, or sometimes the applicant does. That's the time between the time you accept the application and the public hearing opens, 65 days. If the applicant isn't ready for some reason, they might say, I need an extra 10 days, and they'll give you permission to extend that. So they've taken that 10 days off the additional 65, now they have 55 days left. More often than not, the time gets used up in the public hearing process. Because if you only meet once a month, 35 days might give you 2 meetings, probably no more than that. All right, if you meet twice a month, it'll give you 3 probably. And there are times when that's just not enough time, especially if there's modifications to the plans along the way, because there are people that raise concerns, either the public or the commissioners or staff has raised concerns, and the applicant says, no, I better change this, or I'm not getting the approval. All right, so then that goes back to the drawing board, so to speak. So that's where you most often see the continuances or extensions. You rarely see them on the closed end. The end, after the public hearing is closed, you got 65 days to make a decision. It's rarely that you need more time than that. But there are circumstances, you know, that in winter, you might lose a meeting to snow. Or you might lose in the summer a meeting to lack of a quorum. You never know what's gonna happen. So, and then you have, after that, what we call the legislative type decisions. All right, and those are the types of decisions you have total discretion over. All right, these are changing the boundaries of your zoning map or changing the text of your zoning regulations. Those are legislative type decisions. And the court said, who are we to interfere in any manner with those kinds of decisions? You 7 people know better what your community needs, how the zoning regulations should be shaped, how the boundaries of zoning zones should be shaped. We're not going to interfere. And you might get a text amendment, and you might think, it's Tuesday, and I never approve anything on Tuesday. You would never say that on the record, but you could think that and say, so I'm not approving this. And no one would be able to change your mind. You just might say, it's not good for the town. We're not ready for this, or whatever it happens to be. So, and overturning a legislative decision is extremely difficult. I'm not saying it doesn't happen, all right? But it has to rise to a very high standard.
Well, do we need to collect, for if we, one of these types of permits, do we need the collective reasons for denial at that point? Do we need to?
So I've been hearing that a lot lately. I don't know unless they've changed the regulation, I haven't read it, I mean the statutes. Every statute says you shall state on the record your reasons for your decision, for or against. Okay? So a lot of communities, they will do, Enfield, for example, if you vote against something, they want to hear you state your reasons on the record. If you vote for it, you don't have to say a word. All right? So even though the statutes say, for all of these permits, you shall state your reasons on the record for your decision, whether you're for or against. The courts have said, well, even though the word shall is in there, there's sometimes, lawyers love the word shall, because we can sometimes argue that it doesn't mean mandatory. You must do it. Sometimes we call it directory. In other words, you can if you want, you don't have to. So the word shall, when it says you shall state your reasons, is not mandatory. It's directed. You don't have to do it if you don't want, because the court would say, well, we really, when you use the word shall, we know it's must if there are consequences for not doing it. And there's no consequence for you not stating your reasons on the record. The court's not going to say, you didn't state your reasons, we're approving it. So, to the courts, the word shall, in this particular instance, means you may or may not, up to you. Now let's talk about what reasons for approval or denial are. I don't care what your reasons are, but, you know, Art says something. This is the reason I'm voting for this. Christine says, this is the reason I'm voting against it. You know, Jen says whatever. Those aren't reasons for approval or disapproval. We call those individual utterances. That's the phrase that the court uses. They're not reasons for, there might be your reason, but it's not the reason.
So when it's individual, they're
That's right.
utterances.
So if you want to draft
Yeah.
a collective, right, reason for approval or denial, you have the right to do that. Some towns, staff will do that. They'll write you something up and say, collective reason for denying, give you two, the correct collective reason for approving. And you can adopt one of those, or you have to say, no, we're not going to give it, we'll just, I'll let people do their individual utterances, but I don't want to state a collective reason of the board for denying or approving something. And the reason that it's, go ahead.
What would be done by a motion though, right?
I'm sorry?
A collective denial or approval list of reasons would be done by motion
Yes.
formally?
Correct. That's the way I would recommend that you do it. Or would be built into the one motion, the omnibus motion to approve something. We approve it for the following collective reasons. Blah, blah, blah. All right? And the reason that I'm not a big fan of doing it, personally, is that if you were to get challenged on any decision, which you know anyone can challenge, or people who are aggrieved can challenge the decision of this board by taking an appeal to the Superior Court in a certain amount of time. It's 15 days after the notice goes in the paper. That starts the 15-day appeal period. Not 16 days, it's not 15 days and 2 hours, it's 15 days. All right? And if I have a case where you, the commission, made it a collective reason for denial or approval, the court's not going to go beyond that statement. So if you say, I'm approving this because the frontages are too small, the areas are too small, the coverages are too large, and that's something you adopt as a commission when, let's say, you deny it because of those reasons. When it goes to court, the court's going to look at those 3 things only. Because you collectively said those are the only reasons. You had an opportunity to put 100 things in there, you chose 3. And if those things, the court finds that you exercised an abuse of your discretion, right? You have discretion, you abuse that discretion by turning down this application for those specific 3 reasons, they're going to say decision overturned. If you don't say anything, then the court is obligated to look at the entire record. Anything that happened during the public hearings, all right? And both sides can argue, all right, maybe it wasn't one of those 3 things, but it was something else that I can hang my hat on. Or some other reason that the guy who got denied can say, you violated this or that, so.
So you would suggest stay away from that?
I would generally suggest that,
Okay.
yes. It's very rare that commissions do that. Some
Okay.
commissions are, because it's hard to do on the fly.
Right, well, that's the thing
You
too,
know what
because
I'm
you gotta
saying?
sit here and talk and draft something up,
So
right?
I
have a question.
But we've done it in this commission, we've put on
For
the
approvals, I
record
think.
reasons why we've denied.
Collectively.
Yeah.
Okay,
and you're
that's
saying-
fine. You can do
And I
that.
thought that
No,
was
that's-
actually under,
We've done, it says something.
Utterances.
That's
We
We've
haven't-
done utterances.
We haven't,
Yeah.
at the end, said, these are the reasons why we're denying it.
Right,
I
there's-
thought we did, but I could be
I-
remembering wrong.
There may have been
you may have,
There
Bill
might have
would
been
know
like
better than I do.
1 or 2
But
times.
you, Christine, you saying why you're voting no
It's an utterance.
is an utterance.
Yeah,
It's
by
not a
rights,
collective
I've got it
reason.
here in my notes.
Yeah. Okay.
So I'm just thinking of the situation specifically a special permit where you have criteria that needs to be met and you are finding that that criteria is met. How might that be different if you're reading that on the record? Just even if it's just generically like,
All right, so if you want something, if you are in the mood to do such things as have a collective statement for approval, you make it as general as possible. For reasons as, all right, for reasons that are established by the entire record, all right, and by us making a finding, right, because the
right, and just
the
listing.
regulations say you
listing
must
the
make a
regs.
finding of this, you've
Yeah.
met the standards. You
Right.
might say, and some towns have this standard language, they use it every time, all right? This is our language for approval of a special permit.
Right.
For reasons as depicted in the record,
Mm-hmm.
and for the fact that we've made the special findings as set forth in 14B, 1B, those findings that you're supposed to make, we say we're gonna make all those findings. And yes, so some towns do that every time. Just, and they have, they have a okay. In addition to what we would call site-specific conditions, you have the general stuff. Yep, you proved to us you met the standards and the regulations, and we make the specific findings that you did. And then, in addition to that, we're going to require that you keep the lights off from 10 p.m. to 7 AM or whatever conditions you think are reasonable. So I want to jump backwards for a second and talk about, and this is a very nuanced thing that Jake, you mentioned. We put conditions on site plans. No, you don't, because you're not allowed to. So what you're allowed to do is to approve with modifications, or deny. So what you think of as, like if you were sitting here talking about approving something and I was just happened to be in the room, waiting for my turn, all right, to talk to you as your counsel, and I heard you use the word conditions, I might step in and say, no, Mr. Chairman, I think what you're doing is you're approving this with the following modifications. But the modifications have to be geared towards the standards, right? And in the site plan, if there's no standard for illumination or hours of operation, then to modify the application would be inappropriate. But I do know you have illumination, that's one of the requirements. I don't know if hours of operation is in there too as a site plan requirement. But on special permits, you can condition the hell out, but it's gotta be, something related. Art had a
Well,
question.
yeah, I mean, I was getting to the following modifications, but that also sounds like we had done this a couple times, but where we have the applicant say, yeah, I'm okay with doing that, but I prefer not to go back to zero and start over again.
Mhm.
But those kind of
That's the
modifications are
applicant being
agreed to.
deferential and agreeable to.
Yeah.
Because they want their approval. In conversations I've had with clients when I've been sitting over there, I say, they can't do this, all right? But do you want to fight it or just agree?
Yeah.
And they usually say, and I'll say, yeah, we're okay with that. Because likelihood of anyone else challenging that is and then they're all, but let's say you do something that's not appropriate, inappropriate condition or inappropriate modification, and somebody challenges that, then there's a whole level of appellate law as to what happens from there. Okay, we agreed, the court says you didn't have the right to do that even though we agreed, so we're gonna strike that from your list of conditions and modifications. And the next question is it so integral to the entire approval that the entire approval must be stripped away now? And that gets into, that's very nuanced stuff for zoning law.
Carl, we're talking about site plans, right?
We're past that.
Okay, well,
But-
I'm just looking at
Well,
this
you mean
part
about
here.
modifications?
Well, no, I just read, because we were talking, I have here, it's section G, it says a decision to deny or modify a site plan shall set forth the reasons for such denial or
Mhm.
modification.
Right.
That's in
I
8-3.
said it's all over the place. Shall.
Well,
Right.
that's an imperative, right?
No.
Oh, there was no shall?
No, there's a shall.
Is
It's not an imperative.
I thought the
No,
difference
shall-
between
shall
shall
is
and
the-
may is that may is.
Not always.
But no, it's a shall. Shall is an
I
imperative.
just went over that.
It's a shall with no
It's
consequence.
a shall with no consequences, which the courts say is not an imperative. It's not mandatory.
All right, I must have been thinking about something else. Well, how is there no consequences?
If you, let's say this specific topic, you do not make a collective reason or statements of denial or approval, even though the statute says you shall do this,
Yeah.
all right? No one can take you to court and say you have to overturn that decision because you didn't do that. The court would say, no, that shall does not mean shall. It's not mandatory. It's not an imperative. We've decided that 40 years ago, and we're not going to revisit it.
Well, who makes law?
The judges do.
Well, but no, they're not,
Yes, they do.
well, I respectfully disagree.
Okay, well, go down to Hartford
They're court
and
decisions.
and when a judge says to your client, you're getting sentenced to 50 years in jail, you can disagree with them, but that's the see what I'm saying? Until the Supreme Court acts, that's the law of the state. Or the legislature acts and says, all right, everyone's talking about this word shall in 8- whatever you just read, and we understand what the courts have said, but we don't like that. when we say shall in this circumstance, so they'll put an L, they'll amend the regulation or the statute and say, when we say shall here, it shall be mandatory, whether there are consequences or not. And until the legislature does that, the law in the state of Connecticut is, with respect to that statute, shall does not mean must. It's not an imperative.
Well, that just butchers the English language.
Yep.
But you know what?
Have you met lawyers before?
It happened with yeah, the rhetorician, with affordable housing. I mean,
That's a
a
different,
common sense
that's a different
definition of
animal
affordable is something you can afford, but now it's been turned into
Well,
a totally different thing.
that's what a
But
capital A,
it's all playing with
like you
words.
say.
Accessible.
That's what law is,
Legalese.
playing with words.
Different dictionary.
And trying to be as precise as you can, all right? Which is almost impossible. And trying to navigate circumstances that you haven't even thought about, right? The unintended consequences. This is this is the bread and butter for a lot of lawyers. To go pour through this stuff and argue that you want to read it this way, Christine, but this is not me. This is lawyers saying, well, the court has said it doesn't mean that you have to. So if you don't want to do it, you don't have to do it. But to the layperson, I read shall. I think, okay, shall.
That would be a really interesting paper if you maybe examined the advantages versus the disadvantages of stating things on the record.
Just shall will be a lawful order or not.
So that's why Bill and I, to maintain our certification, have to go, well, or
Right.
we like to go every year to hear about case law, because case law means, okay, we've got this written law, how are the judges deciding on these things, especially where there's a gray area, or where something, it says that, but it really in application doesn't make sense, so the courts are like,
So
duh.
you understand that
that's
this little dichotomy did not come out of zoning law.
It shouldn't
This
be
has been
called
going on
case law.
for ever since the first
Right.
tablet came down from on high, or whatever you want to,
Which is shells
But
in
they're
there a
court
lot.
decisions, it shouldn't even be called case law. They should just be referred to as court decisions.
okay. So,
That's interesting.
I guess we beat that one to death, but
Well,
yes,
the legislative branch makes law,
that's correct.
so.
Ask for an order. Yeah, have them.
All right, so.
Those are our four.
Those are the four kind of permits
Permits,
you'll be dealing with on an ongoing basis. So let's talk about, for a few minutes, what.
Wait, hold on, just
Go
a
ahead.
clarification with the legislative kind of text amendment one, the one
Yep.
that we have the most discretion on.
Absolutely, yes.
Okay. Thank you.
And the courts have given you that almost, the courts give you a wide area of discretion in all your decisions.
Right.
All right? So for example, let's say you took it upon yourselves to get a collective reason for decision. And you list 27 reasons why you gave that person their approval. And somebody who is agreed takes you to court and says, you shouldn't have given that approval. And they take the list and they go through it and they prove to the court that there's no substantial evidence on the record for 26 of those standards. You messed up on 26, all right? But you got one right, the court will say, no, one's good enough with us. Now, I'm not talking about standards in the regulations, I'm saying,
Right.
The reasons why you approved this. Because it meant this, it was Saturday, I had turkey for lunch, whatever you put, and then you say, because it met all the requirements of the regulations, and there's 26 other, reasons that are,
All right.
the court will still say, okay, one's good enough for us. If you give a reason, if any one of them is justifiable after looking at the record, then that's good with us, because they give you, they call it a deferential standard. That's why, as a in the zoning realm, as a town attorney, we're fortunate that we have that because we win more cases than we lose, which is nice. You know,
Yeah.
everybody likes to win, nobody likes to lose, right? Because it's hard to overturn a decision by a local zoning commission. Some are easier than others, but it's generally, the onus is on the person who's trying to get it overturned.
Okay.
Very much so. So let's talk about what is evidence, what is substantial evidence. All right, so one of the things somebody mentioned was expert. So occasionally you will get, and this applies in all of these kinds of applications, there almost always is an expert, right? There's usually an engineer. Lawyers are not considered experts unless they have some kind of expertise beyond being able to BS and whatever. So most of the experts you're going to hear are engineers of some kind, civil engineers, wetlands folks, you know, certified soil scientists, traffic engineers, all right, who always, they're a joy to listen to.
So,
Yep.
now, this may sound like a dumb question, but I know
Yeah.
one of the previous things that we had was someone said, this measurement's not right, and they measured it with a tape measure.
Mhm.
And he said, well, you don't need an expert
A local
to,
neighbor.
to measure, you know, whether it's, you know, 10, 12.
I guess that would depend on the margin of error, right?
Yeah. Because
But when you measure anything, you have to have a starting point. And, for example, most people think their property goes to the pavement on their road. Very, very seldom does it do that. The town usually owns, or somebody in the state owns, probably 8, 10, 12 feet of that lawn that you've been mowing, you know, once a week for your entire life. That's town property, generally speaking, especially in newer houses. Because they'll have a 50-foot right of way and the pavement may be 28 feet. So that means there's, 22 feet, 11 on each side, right? That belongs to somebody else. And when people, you know, when some, like utility companies start coming on your property and cutting down trees, and or the town decides they're gonna put a sidewalk on your, what you think is your lawn, more often than not, it's not, it doesn't belong to you. We keep it up because, you know, it's only a few more feet to mow or whatever.
Well, in terms of expert witness, I mean, you don't have to, they need to, basically by their qualifications, prove that what they're saying is accurate, but you don't have to necessarily believe it if you don't want.
All right, so here's the standard there, all right? If one expert solely testifies on something of a complex or which requires some level of expertise, some topic that requires some level of expertise, all right? Even if it might be an opinion as to how, all right, drainage, right? I've met the standards, the slope is required, the depth of the pipe and all of this other stuff, and that, you know, I'm telling you, it's my opinion that this is gonna work, all right? And no other expert testifies about the drainage system. And somebody from the public says, you build another house there, and my basement's gonna flood. Something you probably hear quite often, right? You're gonna disturb the drainage in my area. That's one expert testifying on something that requires expert testimony, whether this drainage technical aspect of their plan is going to work. You are required to believe that expert. If there's no countervailing testimony by an expert, you're supposed to believe the expert. Now, if you have personal knowledge, that's something different. But if
Doesn't the woman whose basement is flooding have personal knowledge?
No, I'm saying you.
Oh, okay.
Yeah, no, but she doesn't have evidence that adding one more house and using this drainage system to alleviate or meet the standard of not increasing the peak flow onto her property, whatever other engineering standards apply. The fact that her basement floods now, and she believes or suspects that it's going to flood more with that extra house, that's not an expert testimony.
Okay.
So Carl, where is that?
Where is
Because-
what?
Well, where does it say that?
In
the
case
commission-
law.
Well, what's the case law, please? Because
I just described it to you.
Well, no, what's the actual case?
There's thousands of cases that
Well,
say
there's
that.
gotta be a preeminent one, because I'd really like to know.
Well, you're gonna have to go
Because-
on Lexis and you can, or some other, you can read, there are, it's so easy to find this stuff. And you can create a Boolean search and you can say, expert testimony,
Okay.
something, and you'll find cases. Now, in opposition to that is if we have two conflicting experts. One guy says, this is gonna work, the other guy says, nope. I got the same credentials he does, I'm telling you it's not gonna work. Then, you get to decide who you believe, or which opinion you take, that's up to you. All right, and the court will never say to you, well, this guy said one thing, this guy said it, but he's been around for 20 years, this guy has only been around for 15 years, you should have believed this guy. No, they're not going to do that. You get to decide who you believe in that circumstance, whose opinion you think is based upon all of the things. Yep.
Can you call in a third expert?
Sometimes towns will hire their own experts. And
Individual?
we were doing that, in actually one of my towns, we were doing that well before it was permitted. So now there's a statute, and they even made it so there are certain towns that don't have full-time planners, okay? And certainly don't have full-time engineers. And the old statute essentially said, if there's some technically complex area of this application that you need your own advice on, you can hire your own expert and you can make the applicant pay for that. Now, they've changed the statute. It says that you can hire any consultant, including stuff that a town engineer might do for you, whether it's complex or not. Standard application, and there's some, so a town could say, I'm not going to have a town engineer. I'm going to use Joe over here, because we trust Joe, and I'm going to tell the applicant, he's going to have to go get Joe's opinion, and he's going to pay Joe whatever Joe's going to bill him. So, but a lot of towns, use that, but they only use it when the ability of town staff cannot handle it, all right? So you don't have a traffic expert on board, right? So let's say you have an application where a traffic study is merited, warranted, right? Even if it's not required, in some cases you might say, hey, we want a traffic. Sometimes it's, it's probably, I don't know, Bill, it's probably one of those things they can ask for in the site plan as well, right?
Yeah.
So, and you might, traffic is a little in the gray area here, right? Because, so you might say, I listened to your report, and you think this is not going to cause problems? We need our own expert, and you can go hire one and make the applicant pay for it. And that's quite often what's done. Some towns will hire their own soil scientists to check somebody else's work. All right? But deciding, because soil scientists, what they're doing is, there's some guesswork, there's some of, there's 27 different types of wetland soils in the state of Connecticut. And, they actually do touch, and they smell, and they look at the color and all that stuff, and one guy might disagree with the other guy. Well, that's a Ferris Bueller 27 soil. And the guy, no, that's a Ferris Bueller 28. Come on. Anyone can see that. So they will have, but they'll generally agree.
So Carl, if an applicant brings their expert in,
Mm-hmm.
we can ask for them to, we can ask for our own expert to come in as well
You can.
and make them pay?
But usually the problem is one of timing. Because again, you have to do these applications in a
Right.
certain amount of time.
Right.
So you might say, you know what, we don't believe your wetlands guy, or we have a problem with the traffic guy, or, so we're gonna hire one, we're gonna ask you to pay for it. And we're also gonna ask you to extend the time of the public hearing, because, you know, our wetlands guy maybe is not gonna be able to get out there, or our traffic guy is not gonna, you know.
Okay.
But let's talk about traffic for a second, because there are certain aspects of a traffic study which are highly technical in nature. Okay? So, you've heard of level of service, right? In a traffic situation.
A, B, D.
It goes, yeah, A to F or something, right? And so you've got these grades for level of service. And there's a chart that says, if I have to wait at a stoplight or a stop sign for more than, I'm guessing now, 45 seconds, that's a level B service. All right, so the longer you have to wait, there's other aspects that go into it, the level of service degrades. So, generally speaking, the traffic engineer will say, if I'm at an A now and I go to a B, that's not a big difference. But the traffic guy is the only guy who can say that it's going from level A to level B or level C to level D or whatever. That takes expertise in the field of traffic engineering, right? So if your standard is that we want a traffic study, and we want you to show us in that traffic study that the level of service at this intersection, whether it's a new intersection or one that you're creating by building new streets, is not going to operate at less than a D, or is not going to jump more than 2 steps in the hierarchy, you need a traffic expert to tell you that. Now, there are very few regulations, none that I'm aware of that, where they get into the weeds on traffic stuff. So if you want to know what the level of service is, you got to ask a traffic guy. If you want to know whether there's a lot of traffic on Elm Street, all right, or Mountain Road, at the intersection of Hill Street and Mountain Road, and cars back up there quite often when the school bus gets out, anyone can testify to that. Doesn't take an expert to know that. I know when I sit in line, right, at 3 o'clock in front of the middle school or whatever, you know, what traffic's like. So there's a difference there. But there are certain aspects of the information you want which can only be given to you by an expert. Unless you're an expert, you can't tell me that this is a wetland soil or it's not a wetland soil. So somebody says, well, it's always wet there. You guys don't really deal with these issues. This is more for the Wetlands Commission, right? If someone says it's always wet there, it must be wetlands. Well, you know, we don't judge that way in Connecticut. We go by soil types. So stuff like that. So, so that's substantial evidence. So here's a case where someone saying something about traffic jams is substantial evidence. But someone arguing over the level of service, you know, I was at the stop sign last week and it took me a minute and a half to get through that darn thing. That's not substantial evidence.
Now, when you talk about soil, is that just wetlands, or is that also include, like, if someone said, oh, well, there's PCBs in the soil, or there's lead in the soil, or something?
Well, the presence of what we call constituents of concern would have to be verified by laboratory. So, or people will say a lot. You'll hear, well, that was a farm, so they must have had something in the soil. All right. Now you're getting, that's a whole different, you know, when you start talking about contamination, you know, if you're trying to make a case for yourself, one way or the other, about contamination in the soil, and I tell people this all the time, they call me, they want me to oppose applications. And I tell them right away, you're better off hiring an expert on one of these issues than hiring a lawyer. If I had a certain amount of money to spend, all right, you spend it on me, I'm gonna get into the weeds on some of the standards and stuff, but I'm not gonna be able to sit there and tell you, convince the commission that they shouldn't approve something because its soil's contaminated. You know, you need experts for those kinds of things.
Is that our question to ask
What?
as a planning and zoning commission?
It might be.
Contamination?
There might be, yep.
Okay.
It might be a question you have to go by the, you know, what's required in the standards.
Mhm.
like in a special permit, I would say yes every time. Because you look, talking about, even about the stuff, forget about the stuff that's written here, the general standards of health, welfare, you know, property values, those kinds of things. Yeah, that's certainly a legitimate question.
But you can't do that in the site plan, is that correct?
I can't think of a circumstance where, again, I don't have your standards memorized, but I don't, you know, because you've already decided that that use is appropriate right there on that site. Not only in that zone, but on that site. So, unless, now there are, some towns will have these standards for approval that are built into all applications, having to deal with groundwater, you know. Wetlands are never gonna be your jurisdiction, groundwater could be in your jurisdiction occasionally. So, but generally speaking, no. That doesn't mean there aren't other local or statewide agencies who would be concerned with that kind of thing.
What are your thoughts about asking for certification of remediation as part of this approval?
If you, so you know there's a remediation efforts going on?
Or assumed?
Okay, in which, or not, nothing we're talking about today, or like on a special permit?
Yeah.
I think that would be acceptable.
Because that's assuring to
Right.
the commission.
Right,
But it's not Bill's department, for example, that's gonna be deciding whether something's properly remediated. It would be
Mhm.
the state of Connecticut.
Right,
It would
yes.
be when the property transfers to a new owner. It would be before, I don't know, before people can live there.
Right.
There's the building department and there's the, you know, state departments that are gonna wanna see that
Mhm.
certification.
mhm.
Lenders certainly before they give money for a project or something,
Yeah.
so.
There's no reason
But it is good, I was just wondering, like, do you think it's appropriate to add on that you would like to see those reports?
Yes.
Once the remediation is completed?
Mhm.
And then that provides assurance,
Right.
even though it's not
Right.
us that's verifying the information.
Mhm. So along the same lines is that each of you has a certain expertise in something. Okay? It may be appropriate, your expertise might be in something that's useful in this context, in the zoning context. So that if you know something, let's say, I don't know, Art, what's your title or?
Professional engineer, but
Yeah.
water quality.
Water quality. So let's say there's a water
yeah.
quality issue, right? And Art wants to put something on the record. He's entitled to do that. Or even if you drove by the property and you would say, well, when I was out there last week, I drove by and this is what I saw. You have to state that on the record. Don't let it sit here in your brain. So Art comes up with something and he's questioning, you know, a guy on, an engineer on water quality. He says, Art, not boasting or anything, he's supposed to do this.
Right.
Well, I have a degree in X, Y, Z, and this is what I do for work, so I know what I'm talking about. So that gives him the legitimacy of the court now saying, well, there wasn't only one expert. There was one sitting right there at the end of the table.
Okay.
Or again, if you visited the site, or you drove by, you know, you can take site walks, you know that, right? You probably don't do it a lot. That's technically a meeting, you know that.
Right.
Right? And the odd part, the problem with that is that this is not your problem, this is just a legislative problem, that if I'm gonna say I'm gonna have an application to do something, and you wanna come out and look, I say, okay, you can come out and look, but my neighbor's not coming. All right? Even that's a public meeting. If a quorum of you meet on the property at the same time, that becomes a public meeting. And I could say, no, even though it's a public meeting, I don't care. My neighbor's not getting on my property, look around. So there's sort of a problem there. So if I knew about that beforehand, your lawyer might say, well, don't have a public meeting. You guys go together, you go together, you go together at different times.
Right.
Then it's not a meeting. All right? And when you go, you've done this before, I assume, right? Probably not often. Wetlands goes more than you know, they go there a lot. ZBA might go, but if you want to take a look, you can. but you're not really, you're supposed to observe, you're not supposed to really engage, especially with each other, because you're having a meeting and, so you just, if you do that, just look around. If you want to ask a question of the applicant, I prefer you didn't do that either, but, if you went out there on your own, you would say, hey, I was out there, because now it gives legitimacy to what you're saying.
Does the applicant have to be there?
Somebody should be there, yes, absolutely, some representative. Sometimes the engineer will be there. I've gone to, where, on big applications, where, the development team, lawyers, engineers, wetlands guys, there'll be like 20 experts walking two of you around the property.
I have a question, and it's kind of directed at, for Jen and Carl. Jen, when you were talking about proof of remediation, I mean, what kind of situations are we talking about where like Connecticut EPA would be involved or EPA statutes
Well,
would
say it's
be?
an old mill building or something and there are contaminants, or there's a certain kind of glue that has something you don't want in it, and they have to scrape the windows or replace the windows or whatever, or asbestos or any of those things, and that's brought up as part of your meeting, right? Like people are bringing that up and you're like, yeah, but there's a chance that that would be corrected, and there's a process for that to be remediated. So the applicant, if they receive their approval and then they go to construct, before they can construct, even before they'll get the lending, for example, or before they'll get all of the levels of approval they need beyond planning and zoning, they usually have to provide a remediation plan that says, these are all the things we've found. They would hire their own professional to go out and take samples, and you need a certain level of samples for a remediation plan to be legitimate.
When does that show up, or how does it intersect? Like Bill, when you get applications, do applicants volunteer that information usually?
For building permits or things like that?
Well, for something that comes before this commission.
The only thing I can think of is sometimes people allege, like Carl pointed out, if it's an old farm property, that there might be contamination in the soil.
Yeah.
That's mostly where this group might intersect or something like that.
And I think if you have an applicant that's wondering, can I even do this? They're not generally going to hire all of the professionals to, spend $300,000 to look at what might be there. They want to know if they can just do the use first. Like, can I even do this in this town? And then, yes, you can do it in the town, but we have all of these safeguards. X, Y, and Z is covered through the Planning and Zoning Commission. All these other safeguards are with the Conservation Commission, or with the Fire Department, or with DEP, looking at all of the hazardous materials. And so there's like all those levels. Yeah.
It's true. The tricky thing with contamination in soil is it's not generally something that this group deals with. That would be handled through the state, DEP.
Right.
So people might be bringing that up at a meeting with you folks, but it's not really something that you
But I took your question, there's known remediation going on, and you want to make sure that it's completed. That would be something you could certainly, I think, ask for.
Yeah.
I guess everything else would have to be done on a case-by-case basis.
Yeah.
I mean, we all, for the most part, most mills have something in there that creosote in the timbers or whatever it happens to be. So. Anybody else have any questions or something that you'd like to discuss?
The special powers, where can I find,
What special powers?
well, the Special Powers Act, when you talked about it, how can I, put something in the search box to find out the year that was adopted in Connecticut and so forth, to get
No,
that?
there's hundreds of thousands of special acts in the libraries, the Connecticut library. So if you want to search something specific,
Yeah,
well, generally speaking, when you, like most towns, I don't know, if you have your charter, you have in your charter or your code book, right? Do you have a code book here? You probably
We
do.
do.
Muni
Big
code,
ordinances.
right?
Yeah.
Yeah, so you'll have, right? It'll be a binder, and the first thing will probably be your charter. Then you have all your ordinances in there. And if there are any special acts that are still apply, or maybe if they don't, maybe if they've been outdated, they might be there. There are certainly, I guarantee you, I know for a fact that there was a special act that created you guys in the 1950s. That one of your forefathers, brought to the legislature. Come to find out, though, it's probably not necessary because you technically have zoning going back to the 1930s, as we found out about 15 years ago.
Yeah.
You did have zoning regulations in the 1930s. One of the very few towns that had those. And then when the war started, they kind of just, the whole thing just fell apart for a decade and a half or so. You have a rich history here.
Thank you.
Jeff had a question.
Yeah,
Oh, Jeff.
Carl, I have a quick question. In the case of text amendments from an outside applicant, do we have to approve those text amendments as presented or as the applicant agrees to changes, or can we make our own modifications?
So you can request modifications, and either the applicant can take that upon themselves, or you could say, for instance, so this is a pretty good idea in theory. We like some of this stuff here, but we want to put our own slant on it. So you could deny it and then take it up and make it your own. The only issue will
Okay,
be...
but we can't hijack basically their text amendment or say decrease the number of units or density or something like
No,
that.
you can do that. You can request that they do
Oh.
that. You can't... One of the issues with text amendments, for example, because, or any application, if you modify the application in a substantial way, and that's a word of art, then text amendments, for example, there must be a notice in the paper, right, that you've got a text amendment. And sometimes you'll put it there in full, and you'll say copies can be available at the planning department. There's also a requirement that somebody place the proposed language at the town clerk's office 10 days in advance of the opening of the hearing. All right, that's a requirement. So if you request, or the applicant makes, or the applicant makes at your request, or their own volition, changes to it, and it makes a substantial difference in the application, it must be renoticed, replaced at the town clerk's office. So it's a very fine line as to what changes are substantial and which are not. And, so sometimes you might call the town attorney and say, all right, we want this, and the applicant's okay, but do we have to renotice it? And then ask them to put a new copy. To be on the safe side, if I was an applicant, no matter what kind of changes I made, even if I thought they were not substantial, I would always give the town clerk the new set, so that I don't have that problem hanging over my head in case someone wants to go to court with me. So, it's a difficult and fine line. So I have in the past taken applicants through that process where I've said, okay, we're, at the direction or the recommendation of the commission, they want you to do that, and you're okay with that, but I think we should withdraw and start all over again. So, but if you don't like something in it, your choices are to ask them to modify it or deny it. Even if it's one little thing. You might like the whole thing, but the density's at 50, and you might be okay with 40. The applicant says, no, I'm not going down to 40, I like 50. That's reason enough to deny it. And if you like the idea so much, you might say, oh, well, let's do this ourselves. That was a great idea. Just not at 50. We like 40. and you can do it on your own. And when you do it on your own, you know that there's no time frames. Your own applications don't have, you know, I've worked with commissions that's taken them 2 years to pass a text amendment. You can go as long as you want. Well, the applicant is, you know, you have to act on their application in a certain amount of time. Or sometimes staff handles that at the beginning. They said, you know what, the commission's, hey, Joe, I know you want to do this. The commission's been talking about this for a while. And they're talking, we're close to coming up with something. Now, I can't stop you from bringing yours, but you may want to consider holding off until you see what we came up with. And they could make that decision for themselves. But once an application is filed, it takes it on its own life. But again, on these legislative decisions, zone changes, and text amendments, you have carte blanche to do whatever you want. If you don't like it for any reason, you just don't vote for it.
Carl, can you speak to amendments creating precedent?
Amendments creating precedent.
Yeah.
In what way?
Well, could other districts request similar
Anyone
changes?
can request a text amendment at any time.
Well, I'm asking, is there any evidence? Have you seen anything like that? Can you speak to it?
Oh, so I do a text amendment for the A1 zone, let's say. I don't have an A1 zone. I don't know. And I approve it, and then somebody says to you, I want to do the same thing in the A2, and you say, no. No, that, again, since it's a legislative decision, you can say, it fits in the A1, but it doesn't fit in our other residential zones.
Mhm.
And they can't say, gee, oh, you did it there, you gotta do it for me. The answer is no. Nope. It's sort of like, it's like a special permit. You can do that with special, you know, just because I gave one to your next door neighbor doesn't mean you get one. Your circumstances are totally different. You might fit the technical aspects of the application, but you don't meet the other general standards, health, safety, welfare, property values, or harmony, or, you know, compatibility.
Or they could.
Or they could, right. But those are all acted on their own. They're individual cases. Just like, you know, the ZBA gives out variances. Well, my neighbor got a variance, I should have one too. Those are supposed to be acted on totally individually, just like special permits.
Anybody have any questions for Carl?
I just have going back to what Jeff was asking, if it's an application for something else, like a special permit, and you want to modify it, that's a different story, right? As long as what you're, like if the
So
commission
again, you mean with the
wanted to
notice problem, the notice issue?
Yeah, and then the commission's really deciding
So,
what's more intense or what's not, is still risky,
So
appropriate or not.
I use a standard, and most zoning attorneys do, but it's not like etched in stone. If you're asking for 25 of something, and I convince you to do 20, it's less, right? Less something, less intense, less dense, less this, less that, right? And if I objected to 25, I could still object to 20, but if I agreed with 25, and you know, I'm probably okay with, let's say, in a butter or something. So we call, that's being subsumed in it. But if I ask for 25 and then all of a sudden I get it, I think this guy might go for 30. I'm gonna ask for 30 now. You might say, nah, no, that's substantial. So there's, again, it's a fine line as to what requires new notice, you know. Now, on the other side of the coin, someone might say, if I read about your application in the paper, or you have a sign out front, or whatever else notice is required here in Suffield, all right? And I go and investigate, and I say, well, I'm not really happy with it, but I guess I can live with it. And all of a sudden, along the process, you change it and make it more something, all right? And you don't put a new notice in the paper, or put the new stuff on with the town clerk or on the website, I have no way of finding out. I said, well, I was okay at 25, but now it's 30? No, deprive me of my right to come in and tell you why 25 might have been okay, but certainly not 30. So that's what all the notice is about.
So renotice does not require a public hearing?
No, well, no, I'm saying if a public hearing is required,
Right, okay.
all right, and I change my application,
Uh-huh.
all right, in a substantial way that makes it more of something,
Right.
I should put a new notice in the paper and say, okay, now the regulation's been changed, and the new version's back at the town clerk's office to give you the opportunity to go and see it. Because otherwise, I might say, oh, no one told me it was changed from 30 to 50. And I could say that's a substantial change, and I would have objected to 50. I didn't mind 30. So there's a really, you know, have to be careful with that stuff. And usually, you know, it's okay for you guys to pass the buck. I mean, the buck does stop there, but you can pass it when you can. So you say, Bill, is this substantial? Should we renotice it? And Bill, you know what he's gonna do? He's gonna call me. And I'm gonna say, you know, well, probably, or maybe, or no, but even if I think it's not, I would say, you know, do it anyway. Put it in the paper again. But if you make any change, it's gotta go to the town clerk, unless it's like if there's grammatical, or, you know, typo, or a period, or a comma, or something that, you know, in this kind of stuff, commas make huge differences. The difference between a comma and a semicolon is like, you know, courts argue about those things. There's thousands of cases that fall and rise and fall on a comma or a semicolon being placed, especially when you're reading statutes. You know, so, and if I'm an applicant, I'm doing the same thing, unless I'm really sure that I'm not changing it substantially. I tell my applicant, we should go ask for a new notice or something. And then I put it in writing. If they say, no, we're okay, I say, okay. You know, I'm not gonna spend your money, it's not my money. But I think you should do it. If you don't, that's up to you. So, discretion is the, what is that? Better part of value or something, I don't know. I'm not gonna, if it was me as an applicant, I'm not gonna chance an application I've spent $500,000 bringing forward. And some of these things can cost that much, between engineering and experts and all this stuff. They, you know, that's a pile of paper you have in front of them, costs $500,000 to produce. I'm not gonna squabble over spending another $75 to put a new notice in it. You're being foolish at that point.
Anybody else have any questions for Carl? Carl, I appreciate you coming out.
Sure.
Yeah. I know it's
So,
another late night.
It's, do you guys use YouTube? Where do you put your videos, right? Zoom. So, you know,
No, we have it for another.
this isn't trademarked, so I don't get royalties if you're watching it.
I've listened to the one in 2022 a few times, and it's just really, it's good. It's good,
Yeah, because
practical stuff.
I'm throwing a lot of, I mean, it took me 40 years to learn this stuff. And,
Yeah.
You know,
Yeah.
and I deal with it every day,
Yeah.
you know, so. Although sometimes it comes back to bite me. Somebody said, I watched the tape and you said something different. And I go, I did? When was that? 10 years ago?
Before
And
that
I go,
court
and I
case
go,
you
oh,
were talking about.
I'm smarter now than I
Case
was
law.
10 years ago.
That's right.
More case law, right, yeah, that doesn't apply to
Well,
me.
you explain it very well, easy to understand.
I try.
No,
Yeah.
I really appreciate it. So what are you doing on September 1st?
September 1st, which one is that?
That's the one that we moved.
The text amendment?
Yeah.
You want me here? Oh, you just tell Bill you want me here. Okay.
Well,
But again-
it's not gonna be here.
Well, not this way. But understand that as important as all this stuff is,
Mhm.
most of the things that, a lot of the things, not most, a lot of the things that can come back to bite you are process issues rather than substantive
Gotcha,
issues.
okay.
Like, should that have gone in the paper again?
Yeah.
That's not it has nothing to do with this.
Right.
Or, you know, should have allowed that person to go on for 20 minutes about something, or
So whose
whatever.
fault is it then?
Hmm?
Whose fault is the process issue?
Well, that's what I'm saying, more cases get overturned on procedural matters, okay? You should have put a new notice in the paper, you didn't. Or your notices were too close together, or too far apart, or the first notice wasn't between 15 and 10, you know, stuff like that. Or you stop somebody from speaking where you shouldn't have. So they're procedural errors. A lot of cases get thrown out on that. Now, those things can be corrected, but it just means you gotta go through the whole, and if it was painful to begin with, it's gonna be real painful the next time around. So if you have any questions about the process, and this usually comes, this is gonna be your job.
Yeah.
You know, if someone brings you a process question, a procedure question, you know, even if you know the answer, unless you're 150% sure, there's no dumb questions when it comes to that kind of stuff. Because, you know, some of these applications are very complex and you spend a lot of time and effort, brain power, right, on going through that. And nobody wants to do it again if you can avoid it. So there's a good book for you to read. It's called What's Legally Required. I don't know, Mike Ziska.
Yeah, the new one, I know.
I don't think, he's kind of like, I don't know how old the latest edition is.
Couple
I
years.
thought he announced another one last year.
Yeah.
A year or two.
So it's a readable pamphlet, and it'll
It's in the big thick book, I think, that we got from the training.
it's only like that big.
Well, no, there was a day-long training during COVID,
Oh, yeah,
and I think that article, I was gonna go in the cellar
yeah.
and pull it off
Mike's
the
book
shelf.
is really, it's, you know, it's concise, speaks to you in a way that, you know, it's not, as opposed to like reading something that, you know, some other, like the treatises on, like 3-volume treatise, you know, that Judge, whatever, has written. He can get into the weeds for that. But in terms of the process, Mike's book is a great tool.
Okay.
And it's not, there's probably, the stuff on, for zoning commissions is probably, you know, a small part of it, because he talks about wetlands and ZBAs and all that stuff. So it might be only 10 or 15 pages on zoning stuff, what's legally required. And if you're interested, he'll put case law in there too, and say, see if you want to read it. He'll put it in there and say, look at this case, you know.
Interesting. Okay.
All right,
Thank you,
all
Carl.
right.
Appreciate it.
Take care, folks.
Thank you.
Thanks, Carl.
Who asked? What? Did someone say my name?
I just said thanks.
Oh, okay. How long did I talk?
Hour and a half-ish. You can make that.
The 22nd, 2022, I think was hour 47.
Oh, there you go.
Shy of the record.
Just trying for the record, right. It's like a big show at a concert.
That's it, man.
For
Do we
sure.
encore now? Do we encore now?
No.
Drive safe, Carl. Thank you. We'll be in touch.
Good night, folks.
All right.
Let Bill know if you want me to come on
Okay.
future dates.
Okay. Thank you, Carl. Moving on, item number 7, reports. Chairman, I have none. Bill.
Yeah, thanks, Jake. So I just had the same text amendments we've been working on. I sent them to the commission about a week after our last meeting, I think in July, and then last week again, just as a reminder. So this is the temporary signage regulation. I had raised the issue, well, not really the issue, but we had discussed this for a little bit, and we came to a decision on the text amendment that we wanted to change to exempt retail establishments in addition to restaurants in terms of the
Yep.
60-day limit and all of that. So last month I had mentioned that to really do that, we either need to eliminate the permit altogether, so all freestanding signs in non-residential zones would just be subject to, you know, some of the criteria, 1 per occupant, you know, secured to prevent movement by wind or other elements, displayed only during hours of operation, 2 by 3 feet, meet all other aspects of the regulations, and behind the street line. So the options are we eliminate the permit altogether, and I think in the discussion, we were kind of like, why don't we just do that?
Leaning towards that.
So, if we do that, that's fine, and the text amendment that I sent, sort of a red line version of what that would look like, it would sort of simplify things quite a bit. And really, we're just making sure people don't leave them out, and that they're not falling over and whatever. From a staff perspective, we have no issue with that, requiring the permit. Most people don't know about it, and then counting the 60 days can be challenging, and so, if everybody's okay with that, we can go with the latest version if we get to the point of a text amendment application, and then we can really discuss it during that process. So I can move forward with that. And then the conversion of one family to two-family dwelling, I had sent that as well. The latest version, everyone should have a copy. Jeff, if you have it on email, I can pull it up on the screen too. I can't see that very well.
I do have a copy.
Okay. I'll share the screen for folks at home. So just to kind of go through this quickly, I know we've talked about it several times. Up top on the left is the existing regulation, and the proposed is underneath the line that sort of breaks up the page. So the changes are in red from, everything on the bottom is new, but we've been discussing this for a while. So the latest changes are in red. So paragraph number 2, we had discussed, if people were thinking of, if I already had a two-family, could I also have an ADU? Or, if I had an ADU, that's an accessory building, could I convert to a two-family? So the idea is no, we just want no more than 2 units per property, a dwelling unit. So paragraph number 2 says that the conversion shall not result in more than 2 dwelling units, to kind of clarify that. And then the other addition was to sort of clarify the off-street parking. Previously, it just said adequate off-street parking shall be provided in accordance with these regulations. So it was a bit open to interpretation. So the suggested language is now off-street parking shall be provided at a rate of 1 space for each dwelling unit containing fewer than 2 bedrooms, and 2 spaces for each dwelling unit containing 2 or more bedrooms, which basically aligns with what our general parking standards are. So if you have a single-family home, you qualify to convert, and the second unit has 2 bedrooms, you need at least 2 parking spaces. So that is the latest. We talked about other things that aren't in here in terms of owner occupancy. There seemed to be a desire to do that, or at least people were interested in seeing that language in there. I didn't add that in. We can. We talked about annual cap on conversions. I don't think there was much desire to have that in there in terms of how many could be approved per year. We don't really do that with other things in the regulations. And then the driveway cut limitations, didn't add language in there that just one driveway per property is required. So this would say somebody could have 2, and we don't regulate that now. So that's not in there. But all of that can be discussed if we have an application and we're in the public hearing process. We can make changes to this, and as Carl just mentioned, it would be our own application. So if we have public hearings and we get a lot of comments that we should be considering these things, we can absolutely make those changes. And I don't think we have to renotice it. Would be in our own public hearing process. So unless there's strong objection, I would recommend we have a text amendment application covering these 2 items and then get into that process. And again, we can take as long as we need to. I don't think the signage will take too long, but the 2-family conversion, we might get comments and we can take those into consideration. But we've been talking about it for a few months, so that would be my suggestion unless someone feels differently.
Timing is kind of really the only thing in terms of like when to, and we're in full control at this
Yep.
point there in terms of when to set public hearings, right, for this? Like, if we don't wanna do it until later in the fall, September's shaping up to be a
Oh,
fun
yeah,
one.
I know we've got a lot going on.
Yeah.
It's not something we have to do right away. I mean, we
Right.
could have an application for the September meeting and set the hearing for November or whatever.
Oh, okay.
If we get to November and then we're like, look, we need more time, there's.
All right, well, let's get the ball rolling then, right? If the
At least
commission
get
is
the
okay with
process.
that, yeah, let's get the ball rolling, and then in September, we'll figure out which meeting we wanna hold the public
Yeah,
hearing.
we have 65 days to set the hearing. I mean, what Carl said, we kind of be on our own
Yeah.
schedule. But,
Yeah.
kind of see how it goes. At least it gets it, into a formal process. I
We
think
agree?
we're at that point. And then see where it goes. Okay. So that's it for me for reports.
Thank you, Bill. Moving on to item number 8, minutes, July 20, 2026 meeting. Brian, you noticed something?
Yeah, just an edit under the attendance, Brian Mussolari was not listed as an alternate, he was listed as just a voting member. That just needs to be fixed.
Okay.
Other than that, I can entertain a motion to approve the minutes with that change.
So moved.
Is there a second?
Second.
Thank you, Jen. Any further discussion? All in favor, say aye.
Aye.
All opposed?
Aye.
Thank you, Jeff. Motion carries. Item number 9, correspondence. None.
So we haven't gotten any written comments from any of the public about the fireplace?
I have nothing official in my email. I know,
Yeah.
Nothing to the
Oh, so
office.
I'm kind of surprised.
Me too.
Usually there's like a couple of emails or something, but everyone, I guess, just decided
to show up instead.
Yeah.
I appreciate you, Commission, being flexible as well with this, with tonight's meeting. It's important we hear everybody, and it's important that everybody gets their opportunity to speak. And so we're gonna start looking for another venue soon. We're gonna get that posted as quickly as we can to move on with that.
It's good to see public engagement.
Yep. With that, I'll entertain a motion to adjourn.
So moved.
The second.
Second.
Thank you, Jen. All in favor, say aye.
Aye.
Opposed?
Aye.
Thank you.
What'd you get first?
I keep forgetting that delay.
He wants to see how everybody's gonna vote first.
It's blank.
Recording
Wait,
stopped.
Did he vote against
Can we leave
adjourning?
15?
Or did he vote
Oh,
for
yes,
adjourning?
folder, but we can take the guts.
Yeah.
Thank you.